Ladies and gentlemen, good morning and welcome to Dublin City University. My name is Federico Fabbrini. I am a full professor of European law and the director of the Legal Research Centre at DCU. And I'm also, as several of you will know, the founding director of the Brexit Institute at DCU. It is my great pleasure to introduce this seminar on international trade law after the EU Anti-Coercion Instrument, which is the fourth bi-monthly seminar that the European Legal Research Centre has organized this academic year. As several of you will know, the Law Research Centre is the main platform for research in law at Dublin City University. The ethos of the centre is to promote interdisciplinary, contextual analysis of the law, and we have a very strong focus on European and international issue. In fact, the Research Centre has several core areas of expertise, including human rights law, privacy, environmental law, and European law and governance. And it is no chance that this academic year we have chosen as a running theme for our seminars the topic of law after, as we call it, which allowed us to shed light on key developments from Brexit to the Glasgow COP26 climate change conference and Ukraine war, etc. From this point of view, I think we are extremely fortunate to have today an event focused on international trade law, and I want to sincerely thank my colleague and friend Niall Moran for championing this initiative. The event takes place at an unusual time. We normally run our seminars in the afternoon Dublin time, but we had to do this to facilitate participation of literally a global cast of speakers which are tuning in from Australia, Singapore, Italy, and of course, Ireland. So allow me to introduce the fantastic panel that we are pleased to showcase to you today in the order in which they will be speaking this morning. So the first to step in will be from Bologna, Professor Elisa Baroncini, who is full professor of international law at the Faculty of Law of the University of Bologna. She's the co-chair of the European Society of International Law Interest Group on International Economic Law, and she also runs the Italian Society of International Law Interest Group on International Economic Law. So a real expert on this field, and I understand she's also involving this morning her students from the Jean Monnet module on globalization and economic affairs that she's currently running. So good morning, Elisa, and thank you very much for joining us. The second speaker in order of participation is Professor Henry Gao, who is Associate Professor of Law at Singapore Management University and the Senior Fellow for the Center for International Governance and Innovation, and another great expert on international trade law issues. Good morning, Henry, and thank you for connecting late afternoon from Singapore. Then the third speaker in the panel will be Weihuan Zhou, who is Associate Professor of Trade Law at University of New South Wales in Sydney, where he's also involved, and I believe running, the China International Business and Economic Law Center in the same faculty. He's also an expert on international trade law and EU-China relations, and we're very grateful, Weihuan, that you are connecting at 6 p.m. Sydney time, so a little bit after closing business on your end, but we really appreciate your cooperation. And then last but not least, of course, our own great Niall Moran, who is Assistant Professor of International Economic Law at Dublin City University in the School of Law and Government, and also affiliated to the Brexit Institute at DCU. Niall has a PhD from Bocconi University in Milan, and I'm also very pleased to emphasize that he just published an impressive book entitled Engagement Between Trade and Investment, the Role of Preferential Trade and Investment Agreements, published by Springer at the beginning of this academic year. So we have really a stellar cast of speakers this morning, and while the topic is very close to my heart as an EU lawyer, this morning my role is purely ceremonial. I am chairing this webinar, and I have the daunting task of keeping speakers within the 15 minutes. So I really encourage them to please stick to time, and I'll give you a heads up when this is running out. Let me only emphasize we are recording this meeting to make it later available also to our graduate students. And of course, there will be time for questions and answers after the presentation. And you can either direct this to me in chat or simply raise your virtual hand, and then we will enable you to speak. And with that, let me also take the opportunity to thank Andre Woolgar, the project coordinator of the Brexit Institute, who is supporting us from a technical point of view this morning. So thanks, Andre, for your help. Now, with that said, and without further ado, I think we should get going with the substance of the conversation. So, Elisa, I'll call immediately on you to get going, and thanks again for joining us this morning. It's a pleasure to see you.
Thank you so much, dear Federico, and thank you to all of you for having me today. I'm very grateful to Professor Federico Fabbrini and to Dr. Niall Moran for the kind invitation and for the hospitality of the Law Research Centre of the University of Dublin. It is a privilege to be here and to participate to this event on a most timely issue, together with major world experts. So the task I've been assigned is to present the Commission proposal for an anti-coercion instrument of the European Union. And I will do so indicating when and how the idea of the need for an anti-coercion instrument was first considered within the European Union. And then I will consider the major elements of the December 2021 proposal by the European Commission. These major elements that you may see during my presentation are the constant attention to the coherence and compatibility of the ACI with international law, the referral to the Sustainable Development Goals. So this proposal is intended to implement Goal 16 and Goal 17 of the 2030 Agenda, so to promote access to justice for all, to build an effective, accountable and inclusive system of institutions at all levels, and to strengthen the implementation of a global partnership for sustainable development. So basically is to promote the international rule of law and to promote the improvement in a sustainability approach of international economic law at world level. And this system, the ACI instrument, is conceived as a system to deter. So the purpose of the anti-coercion instrument is to be adopted in order to be, if it is very successful, never applied, as we will see. But the Union has been conferred the powers to hit, and to hit where it hurts most, with countermeasures. And so we have this highly relevant role of the European Commission and these important weapons in this era of weaponization of global trade for the European Union. But it is important to underline that countermeasures are conceived as a means of last resort. A great part in the instrument is given to enhance the diplomacy, both at bilateral level with the involved third country, but also at international level, and also solidarity among third countries hit, endangered by the anti-coercion measures enacted by another state is promoted. And in order to develop, in order to implement the important tools of this instrument, the principle of transparency is rigorously applied for the investigations, for the involvement of stakeholders and civil society, and also the value, therefore, for informed decision-making is significantly promoted. So when the idea to have a specific anti-coercion instrument started within the debate of the European Union, where let's say that the idea was triggered by the approach, especially of the administration of the United States, towards a constant raising of tariffs in order to use trade not just as it has been conceived within the process of European integration. No, free trade is there in order to bring people together. No, lately we have this use of trade as a geopolitical tool, a geopolitical weapon. And of course, these trade measures causes a lot of disruption, a lot of instability. And so the European Union felt the need to adopt an instrument to contrast this sort of negative development. And the intention was first stated in the letter of intent of the President of the European Commission for the State of the Union 2020, and then the trilogue adopting the revision of the enforcement regulation declared that they wanted the European Union also to adopt an instrument to fight economic coercion by third countries. And since the very beginning, it has been constantly restated the need for this new instrument of the European Union to be compatible with public international law. This has been stated in the declaration when adopting the enforcement regulation, and the attention towards the need to be coherent with public international law has constantly been restated by the Commission and the Parliament, discussing this instrument compatibility with public international law and with the WTO system. And in every document adopted by the European Commission, also in the official web page, so in the disseminating documents, in the document on question and answer of the ACA, there is a paragraph significantly highlighting the need to adopt an instrument that is constantly coherent and compatible with the public international law. Therefore, in the December proposal, in the explanatory memorandum, the European Commission underlines that any union response, and in particular countermeasures, must be commensurate to the injury that they respond to in individual cases, and also in line with the requirements of international law. And in the preamble, in the sixth recital of the proposal by the European Commission, it is always recalled that the European Union is acting within the framework of international law. So again, an emphasis on the international rule of law. And it is stated that it is essential that the Union possess an appropriate instrument to deter and to counteract economic coercion by third countries in order to safeguard its rights and interests and those of the member states of the European Union. Then, in the very first article of the proposal of the Commission, once again, it is repeated that any action has to be undertaken within the ACI instrument respecting public international law, and always having in mind the principle and the objectives, so the values of the international action of the European Union. The way in which this proposal has been developed fully respects the principle of participatory democracy on which it is based the legal system of the European Union. And so public consultations have been launched in March 2021, then a constant exchange of views happened between the officials of the European Commission and the stakeholders, also a public meeting, a webinar in April 2021. There has been a very important hearing last March, the 14th of March of this year at the INTA committee, and the possibility to comment on the proposal of the Commission has been opened until the end of last month. So a very significant involvement of the stakeholders, of the business community, but more generally of civil society. The instrument is important also because it gives a definition of what is economic coercion. And there is economic coercion according to the proposal of the European Commission, where a third country seeks, through measures affecting trade or investment, to coerce the Union or a member state into adopting or refraining from adopting a particular act. So the anti-coercion instrument is conceived, is implemented as a response to the need of the European Union to preserve its own sovereignty, the legitimate policy-making space, and its own economic interest. And two cumulative conditions have to be fulfilled in order to implement the anti-coercion instrument. First of all, there must be an anti-coercion an economic coercion set of measures by a third country, and these must involve measures concerning trade or investment. But again, it is clearly stated and clearly revealed by the structure of the instrument. The main purpose of the anti-coercion instrument is to have an instrument at disposal that is there in order never to be used. So deterrence, the deterrent effect to deter and to fight against even the adoption of economic coercion is the main purpose of the system. It is a very sensitive area, and of course this is mirrored by the very wide and deep preparatory investigation that the European Commission is requested to undertake before starting an anti-coercion measure. And so the European Commission has to take into account, when assessing whether or not to start a case in the anti-coercion system, it has to assess the intensity, the severity, the frequency, the duration, the breadth, the magnitude of the third country measure, and the pressure that arises from this coercive measure. And it has to assess whether or not the third country is trying to settle diplomatically this situation of controversy with the European Union. And it has also to consider whether or not the third country enacting coercive measure does this in answer to a legitimate concern that is internationally recognized. In fact, the dialogue, the bilateral and multilateral diplomacy is significantly strengthened and promoted by the anti-coercion instrument, because the European Commission, when starting investigation, has constantly to dialogue, to open consultations with the involved third country, and it has to explore whether a mutual agreed solution is possible to find, and it has to assess whether attempts in good faith have been made by the third country to settle diplomatically the issue, or the availability to commit to proceedings of adjudication, and this bilaterally but also within an international forum. As I mentioned, it is a very important piece, this proposal of the European Commission, also from the point of view of the principle of transparency. And the European Commission, when opens an investigation, has to publish a notice in the official journal, and it may request the contribution of all the experts, of all the economic operators, stakeholders, and more generally of civil society on the analysis of the economic coercion put up by a third country, and on its assessment, on its evaluation. And so a very informed process. And then once the investigation is closed, before adopting a possible countermeasure, the European Commission has always to invite the third country to react before a date, the date on which the answer, the Union response measure should be enacted. So even in this last part, there is always the need to look for a diplomatic solution to the difficult trade situation between the EU and another country. In synthesis, the Commission has always to be open to engage on a diplomatic solution of the case, and to be constantly open to multilateralize the situation. And there is a specific provision, Article 6, that is for this purpose devoted to the diplomatic solution. It is possible to accelerate, to speed up the answer of the European Commission, but only if there are imperative grounds of urgency to avoid irreparable damage to the Union and to the Member States. The countermeasures that can be adopted by the European Commission are detailed in Annex 1 of the proposal, and they are the traditional trade measures like tariff concession suspension, imposition of duties, of any other charges. You may reduce the possibility of the third country to participate to public procurement in Europe. You may reduce the protection of intellectual property rights. You may step in the protection of foreign services. You may reduce the access to financial services of the third country. You may stop the possibility to use the EU legislation concerning chemicals and concerning sanitary and phytosanitary measures. And especially important is the fact that the European Union, as a countermeasure, can adopt the exclusion or the limited access to EU funding, EU-funded programs. And as I said, countermeasures are considered just only as a measure of last resort. So only if mediation, arbitration, direct consultation or adjudication have been explored, but with no positive result. Another element that I wanted to stress beyond the diplomacy is the constant recall to the compatibility with the WTO system. And so it will be really interesting to see, once this instrument has been approved, it will be very interesting to see how it will be implemented by the European Commission, how it will be, the European Commission can achieve the main purpose, the main target of this instrument to be an instrument with a deterrent effect. And yeah, it will be important to see which level of diplomacy will be implemented and how trade can be used once again to bring people together instead of being just weaponized because of geopolitical reason. And with this, I think I stop there. And I will step in the further debate that will be started.
Thank you so much, Elisa, including for perfect timekeeping. It's exactly 15 minutes, so you are setting a wonderful standard and benchmark for the following speaker, and I'm grateful you so wonderfully outlined the issues at stake here and the proposals by the Commission, which we will further discuss now. So without further ado, I'll hand over to Henry Gao for his follow-up presentation. Henry, the floor is yours.
Thank you, Federico. So I want to start by thanking Professor Fabbrini and Dr. Moran for kindly inviting me. It's a great pleasure to join you at this event today. Actually, I had the privilege of speaking in front of the European Parliament as one of the 3 expert witnesses last month in their hearing on the Anti-Coercion Instrument. So my intervention today will be based partly on my testimony before the Parliament. But because the Parliament operated under a very strict time limit, 7 minutes only, and this time around I'm given 15 minutes. So you guys will also have the benefit of hearing more from me on my thoughts on the issue, because I don't think I really, said everything that I wanted to say about the instrument at the hearing. So I will start by following what Professor Baroncini has really comprehensively discussed earlier. I'm really glad that I followed her, because she gives such an excellent and comprehensive summary of the instrument. So I don't have to do that difficult job. So I would just start by noting, as Professor Baroncini mentioned, that the instrument is supposed to deal with the cases of economic coercion, which is defined in the draft instrument as where a third country seeks, through measures affecting trade or investment, to coerce the union or a member state into adopting or refraining from adopting a particular act. Now, note here that this provision does not name any specific country, but it is obvious that it is targeting the elephant in the room, that is China. So my testimony at the Parliament actually focused mainly on whether or not the instrument would be effective against China. And I think to answer this question, we need to first understand what drives China's act of economic coercion. China, of course, is not a democracy, so there are no elections through which the ruling Communist Party could renew its mandate or legitimacy. Instead, for the past 45 years, the CCP has largely relied on the so-called performance legitimacy founded on economic growth. Because economic growth has leveled off in recent years, however, the CCP has shifted to a new anchor that is the China dream, with the great rejuvenation of the Chinese state as the core message. The great rejuvenation narrative is one in which China will restore its long lost glory, resuming its historical place as the only great power of a tribute system. Such a system includes two key features when it comes to foreign relations and trade. First of all, the traditional tribute system is quite different from the Westphalian system, in which all countries, great and small, are regarded as equal sovereigns. Instead, under the Chinese tribute system, it is modeled after the Confucian social order, in which China, the superior state, would play the role of the big brother, while the surrounding smaller states, as younger brothers, are expected to defer to China. Second, in the tribute system, trade is not regarded as a mutually beneficial exchange conducted according to the Ricardian model based on comparative advantage. Instead, the ability to trade with China is regarded as a reward to be bestowed on foreign tributary states. So as a precondition, such states must first accept their unequal relationship, just as in 1793, Lord Macartney was expected to perform the kowtow ritual during his audience with the Qianlong Emperor of China. Such a ritual is not a perfunctory task without substantive meaning. Instead, it is a subtle way to indicate the tributary state's acceptance of its place in the Chinese tribute system as a kind of a minor partner. We can find its equivalence today in Beijing's insistence that every country should reaffirm its recognition of the One China principle as a prerequisite for a diplomatic and trade relationship. So once we understand the Chinese world review, we can see that actually the EU actually doesn't really fit well into the Chinese system, because individually each European member states is relatively small, but collectively they form the second largest economy in the world. So to deal with the EU, China has employed the tactic of divide and rule, whereby China has actually tried to entice certain European countries, especially the Central and Eastern European countries, to serve as a lever of influence in the European Union due to their shared history of communism and weaker economies. So that is why China has been promoting cooperation with the CEEC since 2012 and trying to integrate them into its Belt and Road Initiative. And this is also why actually I think the anti-coercion instrument can be an effective response to Chinese economic coercion, because the instrument actually turns the European Union's perceived weakness in numbers into its strength and advantage. At the same time, I think we also need to recognize that the ACI in reality could have its limitations, because in democracies, trade and economic sanctions result in slower economic growth, rising unemployment, and the collapse of the ruling government at the polls. There's no such mechanism in China. Again, the basis of legitimacy for the CCP, as I mentioned earlier, has shifted in recent years from economic performance to great rejuvenation. So this means that standing firm against the foreign sanctions may paradoxically bolster the support for the CCP, at least in the short term. And this is also confirmed coincidentally by the famous statement on China's core interests, as announced by Chinese former state councillor Dai Bingguo, where he said the first core interest for China is the preservation of China's basic political system and national security, followed by national sovereignty and territorial integrity, and economic development is relegated to the last place. So in this light, economic losses are regarded as the necessary price to pay for defending China's core interests. Thus, broad trade sanctions that do not directly affect the individual interests of Chinese nationals or firms might not always be effective. But regardless of the effectiveness of the ACI, there's no question that China will retaliate. As a country with a painful memory of unequal treaties since the Opium War, China resents any foreign impositions. Since the enactment of its first foreign trade law in 1994, China has explicitly reserved the right to retaliate against any so-called discriminatory trade measures. And I think the ACI definitely would be regarded as one of such discriminatory trade measure. But the provision in the foreign trade law was only a principle. And China actually has been filling up its arsenal of retaliatory trade measures in recent years, with the adoption of mechanisms such as trade barrier investigation mechanism, the unreliable entity list, the blocking statute, and the anti-foreign sanctions law as some of the more recent examples. And here it is worth noting that actually several of these were borrowed from the EU. For example, China's trade barrier investigation mechanism was borrowed from the TBR, the trade barrier regulation in the EU, and Section 301 in the US. And also the blocking statute was also copied from the EU. And President Xi actually recently called for using legal means to conduct international struggle. So it seems very likely that the legal toolbox would be further beefed up in the coming years. So this would bring me to the next topic, which I really didn't have the chance to discuss at the hearing. That is the domino effect that the instrument would create. I think not just China, but many other countries I would expect to follow the suit of the EU in adopting similar instruments. And we already see such an example. For example, with the adoption of the GDPR in the EU and the copying of the GDPR by several jurisdictions around the world, including China, which adopted its personal information protection law in last year, which entered into effect in November last year. And if you look at the provisions, you can see that actually many provisions copied after the GDPR and also the proposed Digital Markets Act of the EU was also adopted partly by the personal information protection law of China. So this, I think, should be regarded by international lawyers like us as a major concern, because here I would see that we start to see a sort of a race to the bottom. And this could really raise the issue of WTO consistency. As Professor Baroncini has mentioned, I mean, the instrument, when it was drafted and formulated, the EU, the Commission, and also the Parliament during the hearing kept emphasizing that they wanted to make sure that this is consistent with international law, especially WTO law. But that is the intention, and I'm not sure how much that intention could be translated into reality when they ran into problems in the implementation. Because if they want to achieve, more direct results, then maybe WTO rules would be regarded as something that could be, brushed aside for the sake of convenience. And also, we have to recognize that the instrument, when it was adopted, again, I'm echoing what Professor Baroncini mentioned earlier. So it was adopted as a kind of a second best alternative when the WTO dispute settlement system is not functioning well. So the idea is that the appellate body is not effectively in paralysis, and we do not have a functional dispute settlement system, even though we have the MPRA, but the MPRA has a limited membership and is not going to be as effective as the binding reports of the appellate body. So it is basically adopted as a kind of a makeshift mechanism to deal with this power vacuum that is created by the absence of the appellate body. So we have to really look into the future and think hard as to what we should do if, let's say, the appellate body is back. I don't think this seriously this should continue after the appellate body is back, because I see in the ACI the same potential problems that could arise, with the Section 301 of the US. That has been addressed, by the WTO dispute settlement system in the famous US Section 301 case. So I think looking to the future, we have to recognize that the instrument probably would only be a kind of a temporary mechanism. And instead, we have to find more long-term solutions to restore rule of law in international economic law, and especially in the WTO. Now here, there are two potential tools available. One would be to reform the existing rules of the WTO so that the rules can better capture cases of economic coercion, the type that the ACI is supposed to address. But that would have to be in the long term, because I think in the short term, given that there are so many more urgent issues the WTO members are facing, I don't think we really can realistically expect this to be addressed in the short term. So in the short term, I would strongly advocate all WTO members to seriously consider bringing back the appellate body. So how do we bring back the appellate body? I have long argued since the appellate body went into paralysis 5 years ago that we should make use of the existing mechanism of a majority voting that is already there in the Marrakesh Agreement established in the WTO to take the matter into the hands of the General Council and have the General Council force voting on appellate body appointment in the WTO. I recognize that many members are reluctant to do that because we regard that as a nuclear option. But just like this current Ukraine crisis have shown us, when we are in a real crisis like the Russian invasion of Ukraine, we have to take some drastic steps. And if the members of the United Nations can take drastic steps such as expulsion of Russia from the Human Rights Council, I hope that the WTO members would have the courage and the wisdom to adopt the similar mechanisms of a majority voting in the General Council. Thank you.
Thank you so much, Henry. Again, also for keeping perfectly within the 15 minutes you were assigned, and thank you for shedding light on many interesting aspects, including potentially a race to the bottom effect produced by the Brussels effect in this space. I think there's more to discuss though. So without further ado, let me hand over now the floor to Weihuan Zhou for his presentation.
Thanks, Federico, for the kind introduction. Thanks for the invitation to speak on this very important, timely issue. It's a very big shoes to fill after Elisa and Henry's speech. It has been very comprehensive and very insightful. So I'll try my best to dig a little bit more further into the EU Anti-Coercion Instrument, but also to expand the topic to consider China's recent experience with Australia during Australia-China tensions, and also I'll come back to what Henry was mentioning about China's recent regulatory developments. So that will be the three parts of my presentation: the EU Anti-Coercion Instrument, Australia-China tensions, and China's recent regulatory developments, especially those relating to the anti-sanction measures. First, the EU Anti-Coercion Instrument. Based on what I have seen in terms of the proposal and the related materials, I make three brief comments. First, the scope of economic coercion is wide. The current definition refers to a situation where a third country is seeking to pressure the Union into making a particular policy choice by applying or threatening to apply measures affecting trade and investment. It also refers to interference with the EU and member states' legitimate sovereign choices. This broad definition seems to me create a regime for self-judging in terms of the effects and aims. The effects are concerned about foreign measures' impact on trade or investment against the Union and member states, and the aim is concerned about whether the measure is imposed to push the EU or member states to change its policy contrary to what the EU and member states would have wanted to do. It will be interesting to observe how the EU would run the test in practice, especially with respect to whether a foreign measure is intended to push for a policy change. A foreign trade measure, for example, is likely to have impact on trading partners, but does not necessarily serve as a coercive instrument. There are many examples in WTO case law, and some measures may well have a mix of objectives, and the foreign government concerned in most circumstances will simply deny that the measures have a coercive end. Now, second point, the scope of countermeasures is wide and subject to the EU's discretion, which I think reinforces the self-judging regime. It is true that the proposal seems to prioritize consultation and mutually agreed solution and leave countermeasures as the last resort. Where countermeasures are needed, the proposal also adopts the principle of proportionality and some of the major legal constraints borrowed from WTO general exceptions to justify the measures. However, it is very important to note that the WTO legality of such countermeasures does not really lie in whether WTO consultation procedure or legal tests are incorporated into the instrument. Rather, it is the question of whether the measures are used to pursue a policy objective recognized in the WTO agreements. Therefore, the first WTO legality question is whether fighting an alleged economic coercion is a justifiable objective under the WTO. Can the public moral exceptions, for example, be used for that purpose? If anti-coercion is captured by one of the WTO permitted policy goals, the following question is whether the countermeasure can be justified. Now, two further points here. First, even if the proposal incorporates some major WTO tests for general exceptions, WTO tribunals may agree or disagree with the EU's own assessment. Second, assuming that the EU is facing economic coercion by more than one foreign country, having similar impact on EU's trade or investment interests, the EU will be required to treat the two countries in a similar manner in terms of the use of the anti-coercion instrument from both procedural and substantive perspectives. This is arguably required under the instrument itself and the test of unjustifiable and arbitrary discrimination under WTO general exceptions. Now, the third and final point, one of the conditions for the EU to terminate an existing countermeasure refers to a situation in which a binding decision in international third-party adjudication in a dispute between the EU and a foreign country concerned requires a withdrawal of the measure. Now, this condition shows respect for WTO decisions. However, the imposition of a countermeasure before any WTO decision against it takes advantage of a well-known gap in the WTO dispute settlement system associated with the lengthy litigation and lack of retrospective remedy, which incentivizes the practice of temporary breaches. If the EU removes the countermeasure after an adverse WTO decision, it simply uses the gap in the system to buy time for its measures, a popular practice among major WTO members. Next time, when the EU imposes a new countermeasure, the WTO legality of that countermeasure will need to be assessed based on new facts and evidence, so can't be determined until a WTO decision. So we're actually seeing a circle here. In this sense, I think the EU's approach to the use of anti-coercion measures is not fundamentally different from the existing practice of many WTO members in abusing the system, such as the growing use of trade instruments on the ground of national security. Overall, I think the instrument seeks to strike a balance between the need to respond to economic coercion and the use of countermeasures without WTO authorization. However, no matter how carefully it is designed, it will affect the integrity and credibility of the WTO system. It is also likely to attract countermeasures by other major economies like China. Now, I will focus on China's relevant practice in the rest of my talk. Let me first turn to China-Australia tensions, which commenced in early 2020, and to discuss what implications we may have for the EU Anti-Coercion Instrument. The China-Australia tensions arose out of a series of events which led to political disagreements. Many commentators believed Australia's call for an independent review of the origin of COVID-19 in China was the trigger. However, the bilateral tensions had been accumulating through prior events, such as Australia's ban on Huawei's 5G equipment in 2018, treating China as a security threat, Australia's treatment of China as a non-market economy in anti-dumping actions for over a decade, despite its recognition of China as a market economy in 2005. Now, since 2020, China has imposed a range of measures on Australian exports, including anti-dumping and countervailing duties on Australian barley and wine, SPS measures which restricted or delayed importation of beef, wheat, lobster, timber, etc., and informal restrictions on coal imports. I won't have time to go into details, but what implications we may draw from the China-Australia tensions for the EU's anti-coercion instrument? I make three general comments. First, while the trade restrictiveness of the Chinese measures is evident, there is hardly any direct evidence to show that these measures were intended to push Australia to change policy. These measures have been supported by various legitimate policy objectives, such as targeting Australia's unfair trade practices, dumping, subsidization, protection of public health and the environment. This is an illustration of the point I've made earlier about the potential difficulties in making a decision on whether a foreign measure has a coercive aim based on objective assessment of evidence rather than by discretion under the EU's anti-coercion instrument. Second, there is a notable difference between China's selection of policy instruments and the EU's anti-coercion instrument. China's approach is to use existing policy space that has already been recognized in WTO law, such as the use of anti-dumping countervailing measures, the pursuit of policy objectives in a way that can apparently be justified under the WTO law. Whereas the EU, as I said, will need to advance new arguments to show its anti-coercion instrument pursues a legitimate objective consistently with WTO law. Nevertheless, like the EU's proposed recourse to anti-coercion instrument, China's use of trade actions against Australia is essentially a use of a gap in the system which provides room for temporary breaches. Australia challenged China's anti-dumping actions against barley and wine in two separate disputes, and China was very calm in responding to the challenges and in bringing its own WTO case against Australia's anti-dumping measures and on a range of Chinese goods. China also agreed to the MPIA process in the barley case so as to avoid appealing into the void. So therefore, I think it seems that both the EU and China continue to support the WTO dispute settlement system, but they increasingly think of the system as a problem rather than a solution. Now, this is in addition to what Henry was talking about, a panel body crisis, because I think the other concern, or the other major concern, is essentially because the WTO system does not really provide a timely solution to such tensions. Third, the real impact of economic sanctions depends on application and enforcement. Despite China's trade sanctions against Australia, the two-way trade has continued to grow, reaching a record high in 2021. The continued increase in Australian exports to China was primarily a result of the increase in exports of traditional big-ticket commodities. This suggests that trade sanctions or having a mechanism which counters trade coercion does not necessarily mean an overall reduction of trade. The impacts of such instruments depend on enforcement, which typically is subject to other considerations as well. Overall, there are two broader implications. First, China has learned quickly from other major players about how to play the roles of the WTO system and has become as sophisticated as others. Second, we have seen a clear trend of China becoming more and more assertive in its foreign policy and its willingness and capability to use trade instruments as a weapon. Coupled with the rapid developments of anti-sanction instruments in China, the likelihood of China to retaliate against foreign sanctions law or blocking mechanisms, such as the EU Anti-Coercion Instrument, is high. Let me conclude my talk with an eye into the future, as Henry did, based on the recent regulatory developments in China. Now, China has rolled out, Henry also mentioned this, but I just want to give a little bit more information here about the recent activities. China rolled out a series of new laws and regulations to establish a comprehensive framework for the protection of national security. This regulatory effort began with the enactment of the new national security law in 2015, and more recently was triggered by the US-China trade war. Now, Henry mentioned the unreliable entity lists and also the anti-sanction law, which is the most recent. There were other two laws, the export control law and the rules on counteracting unjustified extraterritorial application of foreign legislation, also issued in 2021. In all these measures, importantly, economic security has become an embedded element of national security. They have also instituted a retaliatory mechanism to authorize the use of a broad range of countermeasures against foreign sanctions or foreign actions that adversely affect China's economic security. So my thinking is that this is really very important to say what China will be doing in the future. And also, I think broadly, we are witnessing a clear trend of major economies taking the law into their own hands by self-judging on matters relating to economic coercion, foreign sanctions, national security, and possible countermeasures. This is likely to lead to a spiral of tit-for-tat use of trade and other measures for retaliation, which do not bode well for the future of the multilateral trading system. On the positive side, though, it may also provide an opportunity for cooperation rather than confrontation. And personally, I hope cooperation is the direction towards which governments will eventually converge. I'll stop there.
Thank you so much, Weihuan, for that. I think that was extremely interesting to get the comparative perspective on China-Australia relation. I know Niall was very keen on including that comparative element for a reflection on the EU. So that was really appreciated. Without further ado, let me hand over to Niall, who's now going to complete our round of presentation with PowerPoints as well. Niall, the floor is yours. We can see the PowerPoint well, so the share screen function is working. Go ahead.
Great stuff. Thanks very much, Federico. So I'd just like to say, if anyone has any questions for the panel, feel free to just put them into the chat and then we can address them at the end. So I'm delighted to be joined here today by Professors Baroncini, Zhou, and Zhou. I've only met Elisa before in person, so it's very nice to meet you both, Professors Zhou and Zhou, and thank you all for accepting our invitation to join us today. Thanks also Professor Fabbrini and the Law Research Centre for the work putting in organising the webinar. So I'll be doing my best to build on the comments of the excellent speakers we've had in relation to the Anti-Coercion Instrument. As with any legislative proposal, there are areas of uncertainty in terms of how it will operate in practice, etc. So I'll be examining and probing some of these areas, touching upon some points already raised by the three speakers. But I just want to make clear at the outset that I am broadly supportive of the ACI and its aims. So I'm going to discuss three main areas in relation to the ACI. When might it be invoked, its effectiveness and deterrent potential, and what are the possible effects of the ACI on international trade law. So we've heard the benefits of the ACI from Elisa. It offers speed, flexibility, and deterrence. But it's important to remember that there are flip sides to each of these benefits. So for example, the more flexible an instrument is, the less certainty there may be in how it will operate. If a process is too speedy, it may be questioned whether there are sufficient safeguards on its exercise. But the ACI is a response to darker times, and it offers an alternative to WTO proceedings where this extra element of coercion is present. So in terms of what the ACI is not, I want to contrast it with Section 301 of the US Trade Act 1974. So if the ACI were the EU version of this, then I wouldn't support it. But a key difference is that it's less discretionary. And this is mainly because of Article 2, which contains language that limits the scope of its application, compared to Section 301, which allows a response to acts that are unjustifiable or unreasonable. So as Professor Baroncini outlined, the ACI may be invoked where a measure affects trader investment and interferes in the legitimate sovereign choices of the Union or a member state. So I think it's worth carefully considering this very specific language. What does it mean to interfere in the legitimate sovereign choices of the Union or a member state? China, Lithuania may be a clear example of this, as may be the WTO disputes taken by Australia. But we have to consider the likelihood or possibility of the usage of this instrument being broadened to cover less clear-cut examples of coercion if it were to come into force. So if the usage is broadened, when could the ACI be used? The ACI provides a pathway for a rapid response that bypasses the somewhat cumbersome processes at the WTO, But once this pathway is established, what third country measures could cause the ACI to be used? So Article 2.2 lays down the additional factors for meeting the conditions in 2.1. And so what is the threshold for action for use of the ACI? So the Commission's assessment report gives us guidance on its usage, and that it would be based on quantitative criteria, meaning there must be a minimum amount of money at stake here, and qualitative criteria, which basically is the language we see in 2.2 here, the intensity, severity, frequency, duration, etc. of measures. So I think that the most important filter here is the severity of the measure, because even if the frequency is limited to just one instance, and even if the duration is only since yesterday, a measure may still be coercive if it is severe enough. What are the other filters or factors that might be considered before using the ACI? So let's assume it's not a legitimate international concern under D, and the third country isn't making good faith efforts under E. The ACI isn't being proposed for such situations. We also consider the extent to which the measure encroaches on sovereignty under C. So even if it's not the most severe measure, if it targets the ability of a member state to take a decision freely, this could be deemed to be coercive. So if a measure's encroachment on sovereignty or its severity are the main triggers for the use of the ACI, does this sufficiently limit it being invoked for broader purposes than the disputes we see currently before the WTO? It appears to me that it does not. So the Commission's impact assessment gives an example of coercion in Indonesia's 2019 measure, which is referred to as an unofficial type of coercion. And this resulted in only 40% of EU spirits being allowed into the country in 2020, so a fall of about €6 million. And this measure is deemed to encroach on sovereignty in that it was supposedly taken in response to the EU's ban on palm oil. So if the EU bans a substance and the following year, an EU product fall EU imports fall in the countries producing the banned substance, at what point does this become an unofficial type of coercion? So I think that it's very important that the link between the coercive act and its interference with a legitimate sovereign choice is very clear. And my worry is that if a measure can be characterized as a response to something a member state has done, then you can make a case for it being coercive. And if this is the standard, in a large complex relationship, such as with the US or China, whenever a new barrier is encountered, it won't be too hard to say that this is the result of some choice we've taken, such as banning, palm oil or something like that, that affects the power in question. So the second question I want to look at is deterrence, and admittedly, this is the area I'm least qualified to speak on. But in my view, to make a convincing case for the ACI, you don't need to show that it would deter a major power such as China from trying to squeeze a small member state. If a member state goes against the One China principle, for example, China's motivation to sanction it may well go beyond a standard cost-benefit calculation, but not all states may act this way, and China may not act this way in relation to all issues. But deterrence is supposedly the primary function of the ACI. And while the presence of an ACI would be more of a deterrent than not having one, under the theory of deterrence, the threat of using it should be clear and it should be credible to be effective. So on credibility, there is the question of whether the ACI may be too readily available or whether it would be too difficult to use. And here I think the move away from unanimity is the right thing. So we've seen the difficulties of acting in foreign policy where unanimity has been required in the EU in the past. And the decision to use the ACI will be taken by qualified majority voting. So my worry would be that if anything, it might actually be too readily available. In theory, it could be used without the consent of both France and Germany. Iana Dreyer made the point that there is a risk of those holding the highest offices in the institutions being subject to the influence of a phone call from the Elisa or the Chancellor's office to stop usage of the ACI. And if that were to happen, then there would be procedural issues, of course. But ultimately, my main worry would be that it might be too readily available, and I wouldn't be of the view that it would be too hard for the ACI to be used. And the move away from unanimity is a good thing and makes the ACI a credible threat. So what would be the response of the EU to an act of coercion? In terms of clarity on the use of the ACI, I have questions on this. Would it be clear that if a state does X, it could expect Y in response? So there is a list of countermeasures available where the ACI would be used, but would it be clear to a third state precisely what they'd be subject to in response? How would this be communicated? Is there a lack of predictability here, both internally and externally? So if deterrence is a function of knowing the consequences of specific actions, any lack of clarity in these areas could be really damaging to effective deterrence, in my view. There's also a risk that states would be willing to push the EU in borderline cases, see what the EU can decide on in terms of countermeasures, keeping in mind that it would be a proportionate response. And then if they don't like the EU's proportionate response, dialogue would still be an option. So the third area that I'm going to look at is the possible effects of the ACI on international trade law. So a number of WTO disputes have been initiated in response to alleged acts of economic coercion in recent years. So why not take these disputes to the WTO? The WTO dispute settlement system is not designed to respond to coercion. The argument is that WTO disputes only consider breaches of WTO law and do not tackle the question of coercion and its illegality under customary international law. So recourse under the WTO agreements, it would be no substitute for the anti-coercion instrument, and that's the argument that the Commission is making. However, where there is a measure that is deemed to be inconsistent with WTO law, we now have an additional question. Is the third country seeking to interfere in the legitimate sovereign choices of the Union or a member state? Is the state seeking to dissuade an EU member state from taking a certain act? I've given the Commission's example of coercion in Indonesia with the 40% of spirits being allowed to enter. And although trade and coercion may be separate areas, there is potentially considerable overlap between measures such as this that might be subject to either a WTO dispute or the use of the ACI, and the choice of pathway may ultimately be a political decision. So a second potential effect might involve other states adopting similar measures, the domino effect, as Professor Gao labelled it. So if current trends continue and the ACI becomes a core part of EU trade policy, then I think the EU should expect other countries to adopt similar instruments, similar to the ACI, to Section 301, etc. So whatever measure we're going to define as coercive, we should imagine that any similar EU measure will be deemed to be coercive, and likely our measures will be even more readily deemed to be coercive by third countries. So this raises the question of when does seeking to influence another country become coercive or interfering in legitimate choices? Coercion and interference need to be distinguished from influencing or arm twisting that are common in trade and foreign relations. So what is the consistent standard that we want to be applied here? The impact assessment tells us that it's coercive to demand a country to withdraw support for a UN statement and to link this to vaccine exports. Might other countries then deem it to be coercive if we link certain elements of trade relations with the signature of other international trade agreements, such as the Paris Agreement? Would third countries view conditions such as this as being coercive or interfering in their legitimate sovereign choices? In February 2020, the EU partially withdrew trade preferences for Cambodia due to human rights violations, restrictions on freedom of speech, etc. This was the first time that such a withdrawal had been made. And when I was discussing this with my students, some of them asked me, could that be deemed as coercive or interfering in a legitimate sovereign choice? And I think that the reality is that those situations are very different to the disputes involving coercions mentioned above, in terms of the triggering event and the response that the EU would have. Under the ACI, such a measure likely would not be deemed to be coercive. Article 22D addresses this in that we take into account whether they're acting based on a legitimate concern that is internationally recognized. But would this stop another country labeling such measures as being coercive? Perhaps not. Just because we can see the difference between conditioning trade relations on legitimate international concerns compared to open access conversion does not mean all third countries would view things in the same way and include language similar to that in 22D. So I think that we need to be careful about how we construe interference, because then each time we seek to influence a third country, we may open ourselves to accusations of coercion. So I think we should also expect that if these instruments become more widespread, then EU attempts to influence other countries may be labelled as coercive, and countries affected may not feel the need to address those concerns within the WTO system when they label our measures as coercive. So I think that there are issues here about what constitutes interference with a legitimate sovereign choice, how we apply this standard consistently, and how others may interpret this standard. So just by way of conclusion, for the three areas I focused on invoking the ACI, I think it's very important that the link between the coercive act and its interference with a specific legitimate sovereign choice is clear when the ACI is used. On deterrence, I think that the ACI would be a credible threat, although there may be issues around the clarity of an EU response in advance of a third country taking a specific measure. And for the impact on international trade law, my main concern is that if other states adopt similar instruments, we may see a lot of measures that could be classed as interfering in legitimate sovereign choices. So it's important that these concepts are applied clearly and consistently. I would also echo Professor Gao's sentiments that WTO reform via the return of the appellate body would be the optimal medium-term outcome. I'll leave it there.
Thank you very much, Niall, to you too for this excellent presentation and very precise PowerPoints, and for perfect time management too. So that leaves us with a good 20 minutes time for exchange and debate. I was typing on the chat here to encourage people to please either send me any question directly via chat or simply raise your hand with the virtual hand through the Zoom function if you would like to take the opportunity to ask a question to this fabulous panel of speakers. So who would like to break the ice?
If we're waiting for people to type questions, okay. I have a question for Elisa, actually.
That makes sense, Niall. If there's no question from the audience yet, I think you guys should also exchange feedback between each other.
Yeah, of course. So Elisa, you were discussing deterrence, the deterrent potential of the ACI, and one of the things I've been wondering about is, the idea that it must be proportionate. So if we're building the instrument on proportionality, do you think that'll be, might there be an issue there with it being a sufficient deterrent if a state knows that whatever it does, it'll be a proportionate response?
Well, as was underlined, I mean, this is an important question that requires an articulated answer. So I don't know whether I will be able to fully answer to your important question. The indications and the evaluation that have been given before on this instrument, the ICI, are all to be shared. I mean, this can only be a temporary instrument, and once it is applied, it enters into force. We have to be very careful not to abuse of the instrument, and we must assess the global situation for the domino effect. So the issue of proportionality, I mean, if we have to enter into the last resort stage, last resort part of the application of the instrument, and we adopt a union response measure, as it is called by the ICI, this is, formally speaking, a countermeasure, and the countermeasure has to respect all the requirements of international, public international law, general international law. And among these requirements, in order to be compatible with the WTO system, this countermeasure has to be proportionate to the alleged violation of international law, and strictly, and it has to be designed so as to stop this violation of international law. So at the end of the day, I think that this instrument is a temporary, should be a temporary measure, and basically, in my view, it is an instrument of knowledge, because of the different, the various elements of transparency that are in the proposal. There is one part where the Commission may publish a notice, may request for information from the stakeholder, and a second part when you are dealing whether or not to adopt a union response measure, so a countermeasure, where this may is transformed in shall. Well, in my view, this transparency should be constantly respected and promoted, because it is a way to gather people, to gather stakeholders, to gather economic operators, to gather the EU Commission together with the governments of their country to speak together about an issue that is of the greatest concern for the European Union and maybe for another part of third countries, partners of the European Union. So at the end of the day, this is really, it is successful if we promote this sort of discussion and we avoid the countermeasure part. And at the end of the day, what Professor Zhou said before, I mean, the first WTO legality question is whether we violate, let's say so, the WTO system just by applying the anti-coercion instrument. And yeah, this is maybe the question of the question. And the answer of what we could do has already been provided by the approach of the European Union to the crisis between China and Lithuania, no, with all the discriminatory practices enacted by China versus Lithuania. What happened? That request for WTO consultations has been filed by the European Union. So we use what is still there of the WTO system. It's not a full answer, I'm sorry.
Thank you, Elisa. I wonder whether Henry and Weihuan also want to jump in on this. And if not, I might actually abuse my role as chair and throw in a big question myself, which I think it's perhaps part of this conversation. I found extremely interesting this exchange and the technical discussion on the EU Anti-Coercion Instrument, but I suppose what I'd be curious to hearing from you, you're all leading trade lawyers with great expertise on international economic law. But my question, I suppose, is about the future of globalization or deglobalization. I mean, the trade instrument is a piece, perhaps, of a broader puzzle. At EU level, we have the foreign direct investment screening mechanism, and generally, I think the war in Ukraine is. And previously, of course, the COVID-19 pandemic had been challenging a lot of our assumptions about international trade relations and globalization as we had known it for the last 20 years. So I hope I'm not pushing you too much beyond the focus here on the EU Anti-Coercion Instrument, but I'd be happy perhaps to have your thoughts on what we should expect moving forward, and is international trade law going to fundamentally change as a result of piecemeal changes, but also broader geopolitical challenges we're facing. Niall, shall I put you first?
Yeah, yes, absolutely. Yeah, no, of course, we are seeing these tectonic shifts in the international trade landscape. I suppose my first instinct to the question was that, you know, we should take each development item by item, case by case. And I heard some people saying in response to the Russian developments that, you know, we're now seeing a real politicization of trade. And, you know, I think that deal with each item individually, and just because we have to enact such heavy sanctions on Russia doesn't mean that the overall landscape in relation to the other 163 WTO members has to change, although there might be inevitable fragmentations, etc., resulting from that. So yeah, the anti-coercion instrument, arguably, it could always have been a part of the toolkit. If it functions as a deterrent, it might never have to be used. So I suppose there is a wait and see element, but as I tried to emphasize in what I was saying, where it is invoked, I would like to see that there is a clear link between the measure taken and the interference with a legitimate sovereign choice. Hope that answers me.
Thank you, Niall. Henry, perhaps you want to?
Yeah. This is a great question, Federico. Well, I don't really have a crystal ball, but if I were to guess, I would see that we are in probably another of this era, which we actually have seen before. That is basically between the launch of the Uruguay round and the establishment of the WTO. So basically late 80s, early 90s. Where you saw that the old system was breaking up and they were trying to make new rules, and there was all these disputes between the US and EU, and the dispute settlement system seems to be ill-equipped in handling this tension, across the Atlantic. But in the end, they managed to work out, this amazing collection of new rules under the, WTO, and then we ended up with better institutions and better rules than in the past. So I agree with the sentiment that was shared earlier that this could have some negative systemic implications, but I think with crisis could also generate new opportunities. And I think hopefully the silver lining of all this crisis is that the countries really started to realize that international rule of law, international disciplines are necessary, and we need to really enhance rather than to undermine this international system. And we already started to see some of that, to be frank. I think, in the UN, in the WTO, given the current Ukraine crisis. So I hope that with all these, the members could engage more, and they could achieve more concrete results in the WTO. And I'm actually heartened by the conclusion of the joint statement initiative on domestic regulation for services, right, last year. And that was really encouraging. And I was surprised because 20 years ago, I was actually working in the Trade in Service Division of the WTO Secretariat. And I remember back then that, we had to, as Secretariat officials, we had to sit in the meetings of the Council for Trade in Services. And back then, they were already discussing all these domestic regulations issue, and the members didn't want to move along. So it came even as a big surprise to me that now they can, achieve a major overhaul of the discipline on Article 6 of the gas on domestic regulations right now in such a difficult time. So I think that is maybe some, signal for hope, and I really hope that could be a start of a series of new achievements in the WTO.
Thank you, Henry, also for this optimist take. Perhaps Weihuan, you want to go next?
Yeah, thanks, Federico. And I think the anti-coercion instrument should be viewed in a broader context as what was happening in the past several years, starting with the U.S. deviation from multilateralism, resorting to national security measures. Essentially, I think they are fundamentally the same thing, right? The countries taking the law into their own hands deal with different kinds of measures outside of the WTO system. So I don't think that by itself, the instrument itself will have a systemic impact. The real issue or systemic issue we're dealing with here is really that all the major economies taking the law into their own hands. Like China may not even need anti-coercion instruments like the EU ones, because China now has everything into their national security concern. So everything that affects China's national security, very broadly defined. For example, any intervention into China's decision on what kind of economic system they may have, that could be even a national security issue for China. And that will trigger countermeasures from China. So from that perspective, that will also be, if you define it, that could be similar to what the EU instrument states about interference into the sovereign interests or sovereign states' choice, right? And that China has broadly covered these things as the security issue now. So I think there are kind of fundamental similarities in all of this kind of taking the law into your own hands action. They're trying to create all sorts of regulatory instruments to achieve the same objective. That is, when the WTO can't actually work efficiently, then we're going to take the law into their own hand, into our own hands, because everyone else is doing that. So that's perhaps, but I think I agree with Henry, as I also said in my presentation. I think cooperation is very is something that I would like to say, and I think that after the impacts of the sorts of deglobalization or disruptive globalization impacts on the domestic constituents enough, then we might see a different picture and some, coming back with the political will for cooperation.
Thank you, Weihuan, also for your optimistic word. And of course, I'm coming to you, Elisa. Apologies for keeping you last, but you now obviously have the floor to share your thoughts on these two.
Well, the question by Federico is an enormous question. I just would like some smaller remarks. First of all, with reference to the use, because it is a central the practice that will be developed when this ACI instrument will start to be used. And yes, all the investigations has to be really informed. And attention is put on the impact of the attack, let's say so, economic coercion measure by the third country, and on the impact that it may have the European Union response. And in this case, you speak with numbers, you speak with figures. And this can maybe put at a distance the danger of self-judging, because everything has to be based on this very wide investigation. And another remark is the approach of the business community, of the European business community, to the adoption of this instrument. They are cautious. So they say, on one side, it is important to know that we can organize within the European Union in a certain way, but attention, so the cautiousness of by the business operators, in my view, can entail that we can use really this ACI really as a last resort instrument. Then, with reference to the deglobalization process, we are facing these very challenging moments, because when you adopt a sanction against Russia, they are not a sanction against Lebanon or against Iran or Liechtenstein. So, I mean, Russia has, I think, the 10% of world production of oil and gas. Together with Ukraine, it has the 25% of production of grain. So, you deglobalize. I think that the European Union has a significant responsibility at world stage because of the wide net of the new generation of free trade agreements and the dispute settlement mechanisms that are within these new generation of free trade agreements. So the promotion of the international rule of law, of reliable rules for economic operators, for the civil society to discuss, can happen through appropriate promotion and enforcement of these bilateral nets of free trade agreements. In the meanwhile, that we try to understand what to do to start having again a successful multilateral trade system.
Thank you so much, Elisa. And I mean, I felt guilty of asking this big question, but I'm very grateful that you all approach it. So listen, we have 3-4 minutes, and there is one other question that has arrived to me from Melissa Meager for Professor Gao. Do you think that Singapore would be likely to adopt such an instrument in the future? I think it's a specific question, but we have, I think, sufficient time to address it. So Henry, if you want to approach it.
Thank you. Well, that question is relatively easy. The answer is no, because first of all, Singapore is one of a very few countries in the world which doesn't even have a trade remedy laws. So if you are anti-dumping lawyer, you come to Singapore, you'll be starving because we don't have trade remedies cases. And second, Singapore always try to maintain a good relationship with China. So, for example, in some of the recent statements by the Singapore government, as you can see, they refuse to criticize, for example, China's position on Russia because they realize that, the issue is much more nuanced, especially, for Asian countries. So I do not think, at least in my lifetime, I hope that I would have a long lifetime. This would be adopted by Singapore. So no, yeah.
Thank you, Henry. Of course, we wish you a long life. Clearly, listen, ladies and gentlemen, we are coming to the end of this fascinating discussion and webinar. I will simply ask maybe all the speakers to speak for 30 seconds if they want to add anything to what we have discussed so far, and I'll call them in reverse order. So maybe starting with you, Niall, if you have any further remark, after which we will have to close.
Thanks, Federico. Not much to add, just again to thanks all the speakers and everyone for joining us here today. I suppose by way of a final comment, I think that we need to be careful about making non-interference, a gold standard, because then each time we seek to influence, we might open ourselves up to coercion. Accusations of it. I'll leave it there.
Thanks, Niall. Weihuan.
Thanks, Federico. I don't really have much to add. I just want to perhaps just one very quick comment on Niall's question before about the legality of the instruments under the WTO under the proportionality tests. One thing, first point is that you do have to fit into one of the objectives in the WTO. And secondly, the less trade restrictive tests is not equivalent to the proportionality tests. So that's something to watch out as well. And then there is an unjustifiable arbitrary discrimination tests. So I'm coming back to lawyering in me at the end of the seminar. Thank you.
Thank you, Weihuan. Henry.
Thank you. All I wish to say is that I enjoy this discussion, especially now that the ACI, is generating significant interest. Maybe we could, have a gathering again after it enters into effect. It started being used. I think it would be more interesting to see which types of cases are used and what are the implications. Thank you.
Thank you, Henry. And obviously, last but not least, Elisa, our female speaker in the panel, of course, is yours.
Well, I enjoyed very much talking with you. It has been a privilege. And I think that if I may leave with a message, the message is to implement this future tool of the ACI, like all the major tools, with full respect on the principle on transparency and full involvement, and making the most of the requirement of diplomacy, because what we need today is to talk and to make other people understand when there is something of concern with us, that maybe we will find a listener at the end of the day. But if we don't promote the diplomacy and we immediately adopt unilateral measures, well, this is not the way. And we globalize instead of governing with fairness globalization.
Thank you, Elisa. You said we need to talk, and talk we did. It has been a fascinating seminar, and I really want to thank you, Elisa Baroncini, Weihuan Zhou, Henry Gao, and Niall Moran for being with us today virtually at the Law Research Centre of Dublin City University. It's been a wonderful conversation involving literally speakers from across the globe, from Australia to Singapore to Italy to Ireland. So it has been a privilege for me to be able to share this. Again, allow me to thank Niall for putting us together. We are bringing this seminar to a close with only a minute of delay. So I want to thank all the participants for staying with us, and I want to wish you a nice remainder of the day. If you are on this side of the hemisphere, or perhaps good evening and good night for our friends in the Asia-Pacific region of the world. So, Gore mille mahe, as we say in Irish, thank you very much to you all. And I hope to see you soon at some point, perhaps personally in Dublin. Bye-bye.